So first of all, big welcome to everybody who's joined this webinar this afternoon. I would like to advise you all that the webinar is being recorded, so we will be able to share it after the event. So as long as everybody's aware of that. Just to introduce myself, my name is Chris Elias. I'm going to be the host for this afternoon. I'm a relationship director with Thrings. I'm not a lawyer, I'm glad to say, so no tricky questions for me. I'm a banker by profession, and I'm glad to see that quite a few of my former colleagues have actually joined in the webinar today as well, actually. So good to see you, lads. Good to see you on board. First, the webinar today is part of a larger program that Thrings is providing throughout the pandemic, really, in terms of our Business Health Matters program. As I say, it's a webinar which is designed perhaps to add a little bit of flesh to some of the issues that have been raised by clients already during the last few months, and it's it'll hopefully provide some insight to all of you in terms of some of those key issues. It's the first of a number of webinars that we're planning to run. And indeed, we've got our next webinar planned for the 28th of July, which will be looking at cash flow issues and how they can affect our clients. So that'll be another interesting event. So if I and Callum has now joined us. To great relief for everybody, particularly Kate and Melissa would probably have to pick up Caroline's slot if she didn't arrive. So now we've got all our panel members. Let's introduce them one by one. So we have, I'm sure many of you all know, we've got the delightful Kate Westbrook. Kate specialises in drafting and negotiating commercial contracts. So Kate, give us a little wave so everybody knows who you are. Which one are you? Great. And then we have got the delicious Caroline Watson, who's just joined us. Caroline specialises in commercial dispute resolution. So I'd just like a thumbs up from you. Thumbs up, that's good, you're all on board. And then finally, we have the delectable Melissa George, known as Mel G in the office at Thrings, our own little spice girl, aren't you? Mel specialises in insolvency, both corporate and personal matters. And having seen everybody's presentations in a run through, I think some of the things which Mel is going to cover later on in the webinar, it's a sting in the tail, really. It's fundamentally important, so that's going to be really, really interesting. So a big virtual high five from you, please. Oh.
Hi, I shan't be singing.
No, okay, that's good. So this will be an interactive webinar. At the end of each speaker's individual session, we'll do a little poll. So if there are any key issues which people would like to raise or give comment on, we'll do that, and hopefully the feedback that we'll get from that will be quite important in terms of our ongoing approach. Also, at the bottom of your screen, you'll see a little Q&A button. So if you've got any questions and answers or questions that you'd like to raise, if you just want to fill it in, and what we'll endeavour to do is cover that at the end of the webinar. The webinar is scheduled to run until 5 o'clock, but if there are any pointless fans out there, don't worry, we will definitely be finished by 5. And indeed, if it moves on any quicker than that, all being well. If it doesn't, and we have to pick up any Q&As at a later date, we will definitely do that. So, without further ado, then let's move into our first speaker for the afternoon, and that's Kate. And Kate is going to cover all topics surrounding force majeure. Now, Kate, it's a word that we've heard a lot of late. I thought it was a regiment in the French army. Clearly, it's not. So, if it isn't, what is force majeure? What does it really mean?
So force majeure, it's a legal concept. It essentially forgives a party for being in breach of contract where that's caused by an event outside of its control. The really important thing to know is you have to have a force majeure contract a clause in your contract for it to apply. If you haven't got a force majeure clause, it's not applicable. And that would mean that without it, you'd be liable for the breach of contract, which can lead to you being responsible for paying compensation. Bad news. As to what force majeure really is, it depends on the clause. It depends what's written on the tin. Some force majeure clauses take quite a restrictive view, and they will list out the types of events. I'm sure we've all seen the sorts of clauses: acts of God, fire, flood, pandemic, and epidemic. Those are the two words we'd be looking for in those clauses in respect of COVID. You can also get clauses that have a more non-restrictive, non-exhaustive list of force majeure events, and that might refer to any event outside the reasonable control of the parties. That's ideal because that gives you a lot more scope. Very, very likely that the current pandemic would be included in that kind of event outside the reasonable control of the parties. But whether your force majeure clause applies to your particular contract is very dependent on the facts. The details are really important. So to answer your question, because it's so exciting, force majeure, I've never spoken about force majeure so much in my career. If you have got a force majeure clause in your contracts, you can avoid being liable for breach if you've delayed or there's non-performance because of the circumstances of the COVID-19 pandemic. But the devil is definitely in the detail.
So what shall I do then if I knew I wasn't going to meet the contractual obligation as a result of COVID or the pandemic? What's my course of action?
You firstly must absolutely look at your contract. Look at the contracts that might be at risk of delay or non-performance and assess whether you've got a force majeure clause in there. They may not use the term force majeure in the clause, that's important to say. And if you do have a clause, you need to review it really carefully and follow it to the letter. Part of that will involve looking at the situation that you currently find yourself in. Does that fit the definition of force majeure as written in your contract? That's going to be a matter of fact. Don't just assume that because it's linked to COVID that you're covered. It might not be. So if there's any uncertainty, do talk to your favourite lawyer. It might be your staff can't work because they've fallen ill with COVID. That's clearly linked. If your whole workforce has been quarantined due to the number of infections in your workplace, or because you're not permitted to travel to the country in which you're required to perform services, those are all kinds of force majeure situations. Once you've identified whether you've got a clause, is it an event? You then need to look at the clause to understand what do you need to do next. Probably it will say you need to notify the other party that a force majeure event is occurring. You may also need to have to try to mitigate the effects of the breach. So use reasonable endeavours to try and stop the force majeure event having a bad effect on the contract. A couple of really important things to note as well. Always make sure you follow the notices clause in your contract. It's a clause at the end, nobody reads it really other than to put in addresses. Make sure you send your notice of force majeure to the correct address as set out in the contract. Just take real care following the force majeure event. Your actions following the events of COVID are really important. Try not to shut off avenues for actions which could close off your options to get back on track, because that could be looked at negatively if you were ever to end up in a court, which we obviously hope you won't.
But what happens then if you haven't got a force majeure clause in your contract? Are you still liable for issues if it's COVID related?
Possibly, that is a risk, but not necessarily. It's always best to use a force majeure clause to get you out of jail if you have one. If you don't have one, it's possible that something called the legal doctrine of frustration will help. This is the sort of thing we only ever tend to look at law school and never again. But what this effectively does is cancel the contract if it's impossible for it to be performed, or if the situation has caused a fundamental change. So it's possible that COVID could have created frustrated contracts right now. If it applies, all of the rights and obligations in the contract are cancelled, not suspended, so it's different to force majeure. It's possible for a party that has already paid monies under a frustrated contract to claim some or all of them back. So that's not necessarily ideal either. So for those reasons alone, as well as the uncertainty around frustration, how exactly it would apply, because we'd have to be relying on case law. I'd usually much prefer you rely on a force majeure clause.
Okay, so what if you do feel that the contract is being frustrated? What's what course of action have you got?
Again, talk to your favourite lawyer, Chris. Honestly, it's really fact specific. So your initial steps are going to be the same. You're going to assess the situation, understand whether or not the contract genuinely has been frustrated. But ideally, what you do is you notify your counterparty. You tell them you believe the contract's frustrated. Ideally, you get their agreement as to that to stop any disputes arising.
Oh, good, brilliant. Thanks very much, Kate. That's been very useful, I'm sure, for everybody. Now we're going to try and see if the technology works, and we're going to try our first poll of the day. Right then, and here we go. This is polling force 1. I'm going to all panel to vote. Launched. Right. So there we are. Hopefully everybody gets that poll and can perhaps have a look at it. And whilst we're doing that, Kate, is it worthwhile? We're talking about the theory. Have there been any live cases that you've had recently, as far as FM is concerned, that you could share with us, really, just to bring it home to people?
Yes, we've had a lot, as you might expect. So on the sort of supply of goods side, we've worked with one of our clients who they were not able to get their shipments from their Chinese manufacturer in time to supply a large customer because the Chinese factory was shut down due to the COVID pandemic. And that had quite a significant knock-on impact to their customer contracts. Actually, to be fair to their customer, they took a very pragmatic approach and a very reasonable approach, and what they required was evidence of the force majeure situation, which we were able to provide quite easily, and that resolved itself quite well. I found during the early days of lockdown, clients and their customers and suppliers were really quite understanding. Another area where we've had an awful lot of inquiries relates to venues, whether they be wedding venues or venues for business events, both on the venue side, but also businesses who are looking to engage with the venue. Obviously, they're currently not, most of them are not permitted to operate at the moment, so that's a clear force majeure situation. Fast forward to a couple of weeks hence, when venues might be able to open, but perhaps can't accommodate the numbers that were expected. That's going to be quite an interesting position. So I think there will be quite a lot of interest in that. But what we've been encouraging our clients to do is take a pragmatic approach. If we can negotiate with the venue, or if the venue can negotiate with its customers and reach something mutually agreeable, that is much better than relying on a clause in a contract, or starting to litigate or ruining the relationship. So we're finding that that businesses are definitely open to negotiating the position.
Good. Well, let's fingers crossed. Let's hope common sense and pragmatism wins out at the end of the day. Then, so I think that'll be the best result for everybody, really. So it's quite interesting. The polling results are in, and I see quite a few people. When it comes to, do you know whether you've got force majeure clauses in your contracts? I'll need to check. Seems to be coming through loud and clear. So if there's one thing that people take away from today's webinar, it's probably check and double check, really, because yeah, very interesting. So that's good. Right then. So if we move on to Caroline. No, I think that's if you're finished there. Okay, so
I am. Thank you.
So welcome, Caroline. Welcome aboard. And we're going to chat about business interruption cover.
Yeah.
So there's been lots of press recently about business interruption policies not covering COVID and pandemic-related issues. But in that case, what do they normally cover? What would you expect your BI policy to cover?
Yeah, so I think the press has surrounded the fact that lots of people had business interruption insurance in place, and assumed that if they were affected by an event outside of their control, such as a government-ordered lockdown, that their losses would be covered under that policy. And then when they have come to look at the fine print of that policy, that actually hasn't been the case. Generally, business insurance interruption policies are linked to property insurance, and the risk that is insured is for damage to that property. So, for example, if you had a flood or a fire that prevented you from trading, your business interruption policy would kick in to cover those losses. The issue that we've all seen in the press is why those policies haven't stepped in to cover pandemic risk.
Mm-hmm. Are there any policies out there then that are likely to cover COVID? Are people likely to have that sort of that reassurance?
Yeah, I think so. As I said, the majority of standard business interruption policies weren't designed to cover pandemic risk, and it is unlikely that you would be covered under a standard policy. That's the bad news. The good news is that if you purchased a policy extension, you are more likely to be covered, and the types of extensions that you would want to look out for in your policy are those that provide cover for example, a notifiable or identifiable disease occurring within a vicinity of your premises, or perhaps being denied access to your premises for reasons not connected to physical damage to your property. Coming back to the press point, one of the things that's there's been a lot of press coverage on is that some insurers have taken the stance that even on the face of policies that would look on plain English interpretation to cover the exact situation that we've been in, the insurers have stepped in and said we're not here to cover pandemic risks, and we're not paying out. And Hiscox, for example, has kind of had a lot of press about its
a lot of bad press on that, haven't they?
Yeah.
So I can't remember. I think I read it in one of the Sunday papers that the FCA was considering taking court action on behalf of some policy holders. So is that correct? Is there hope for some people out there?
Yeah, that's right. Well spotted. The FCA, which is the Financial Conduct Authority, which regulates insurers, has highlighted that there are cases of real ambiguity on standard policy terms affecting the types of extensions that I mentioned. And in cases where there is real ambiguity as to whether whether an insurer should pay out, it is bringing a test case on behalf of policyholders in the High Court to determine issues which it thinks are very widespread across the industry. The types of questions that case is looking at are whether, for example, COVID occurring within 25 miles of your property is a notifiable disease occurring within 25 miles of your property. And there are a whole raft of questions that case is looking at, which have identified the key areas of ambiguity in policy provisions of 8 very major insurers.
Yeah, right. So what should a business do then if they've had cover refused, but they disagree with the policy interpretation? I guess really.
I think the FCA case, when the decision comes through, will provide a lot of clarity to some of the main cases where there's ambiguity. The FCA at the moment estimates that about 8,500 policyholders are likely to be affected by that decision. So the first thing is there will be clarity arising out of that decision. However, for policyholders, that court case is being expedited and it's being dealt with very quickly. but we're unlikely to have a decision from it before early August, and it is ripe for appeal to the Supreme Court for whichever party it goes against. So I think getting some finality from that decision isn't likely to happen until the back end of the year at the earliest. So policyholders that are affected, if you take early advice on the provisions of your policy, and you know, as Kate says, talk to your favourite lawyer. And this is not us trying to drum up work; it's us trying to protect your position as policyholders. So take early advice. There are things you can do. You don't have to wait for the FCA decision to start to advance your claims. Very practically on the ground, you need to keep a note of what all of your losses are, and if you needed a forensic accountant involved in that process, you know, that's something that needs to be looked at. But take an early and accurate record of the losses that you're experiencing. There is a route through the Financial Ombudsman to decide these policy refusals early, which is designed to be a cheap and quick process for claims up to 350,000, and that is a very swift route for a business to take if it wants to. The third point is there may be different ways of resolving disputes set out in your policy, and that needs to be looked at quite clearly. Again, we'd suggest you took early advice on quite what the way through disputes is that's set out in your policy. Brilliant.
Okay, well, thanks very much for that, Caroline. And before we launch our second poll, I'm sure the astute of you will have noticed that we have two Kate Westbrooks on our on our screen. But Caroline, who's just, I assume that's probably something to get you into the meeting in the first place. Caroline, yes.
It's to do with the technical issues.
Thinking on your feet. Well done. That's what I like. So right then, whilst we launch our second poll, again, are there any sort of anecdotal or sort of you know, client experiences that you've had as far as business interruption that we want to that you could share?
Anecdotally, we have heard that some claims aren't actually making it through to insurers; they're being denied at broker stage. If that affects you and if that affects your business, press at the door, push at the door. You need that claim to get to the insurer, and it is not for your broker to refuse or otherwise. So I'd say that's kind of first practical tip on that. The second thing that we're seeing is that some insurers are paying out, but for very limited losses. So you know, a loss is related to a supply of a consignment that had a particular shelf life, for example. But any losses that are paid out will be within the strict limits within your policy anyway. So you would need to review what your policy limits are to determine whether refuting a denial of a claim is worth your while for what you might get at the end of that if your insurance does pay out.
Mm-hmm. Good. Well, the astute of you might have noticed then I was a little bit slow off the mark with that poll, but I managed to work the technology out, and the votes are coming in on that, which look fairly interesting as well. So again, perhaps we might leave that and pick that up towards the end, I think. So that's yeah, those are still coming, those are still running in, so I'll leave those go as we speak. So I think we've time to come now to move on to our third and final speaker for the afternoon. So Mel, welcome aboard. Glad to have you on speaking. As I mentioned at the start of the webinar, there's some quite important terms coming down the line, aren't there? I certainly hear that the insolvency legislation is changing as far as contract terms are concerned. So can you explain the background there?
Yes, I certainly can, even though I'm not Kate Westbrook. I'm assuming I'm still a third musketeer here.
Yes, you are.
Yes, changes have already happened. They came into force on the 26th of June of this year. Changes are being made to support companies that are seeking protection under a formal insolvency process, with a view to that company either securing a better return for its creditors or even better survival as a going concern. Traditionally, contracts for supply of goods or services often allow suppliers to terminate or withhold supply if the customer enters into an insolvency process or is at risk of insolvency. That right enabled the supplier to place the customer on stop or to require arrears to be paid as a condition of supply into that customer when it's in an insolvency process. What this change does is mean that the supplier can no longer terminate the supply simply because the customer enters into an insolvency process, nor can they rely on any ground for termination which existed before the insolvency process commenced if they've not already exercised their right. So practically, for the supplier, it means that they risk being forced to continue to supply on credit to a customer that's in a formal insolvency process where they may already be owed a substantial sum of money. This may affect their cash flow, it may affect their working capital, and therefore create issues internally or within their own supply chain.
So, and does that apply to all contracts for goods and services, or any specifics? Or
not quite. There's an exemption for contracts for the supply of financial services, as well as certain other contracts for essential supplies, which are already subject to a level of protection. Those include utilities or provision of IT services. The scope, I should say, is very broad. It applies to supplies of all contracts and services unless they are exempt. So if we extrapolate this, it can extend to licenses for intellectual property. So this means that brands that are licensed for use by customers, which are traditionally terminable on the insolvency of that customer, in order to protect the brand, may not now be terminated simply because of the insolvency process. Franchise agreements may also be caught. So this is very, very broad.
cool. Okay. So, from a banking perspective, you wonder, if people have to continue supplying. So, is there any guarantee that they're going to get paid for any further supplies?
The reality is they should be. The timing will very much depend upon the process which the customer enters. So if they're protected by the new moratorium, which was also created on the 26th of June, then they should be paid in accordance with the terms of the contract. Otherwise, they can terminate supply. If, however, the customer's entered into an administration process, practically speaking, the administrators tend to agree terms of payment and credit and broadly tend to stick with that. But if we look at the letter of the law, the administrators don't need to pay out their expenses, so that includes this order of supply, until they're about to close the administration. So what I'd say really is that I'd recommend that people look at their contracts and check whether there are provisions that enable them to terminate if the customer doesn't pay on time, because those sort of provisions remain enforceable post insolvency process if the payment isn't made when due.
Mm-hmm. So, what should suppliers do now? What should they do if they can't continue to afford to supply a client?
I think there's two elements to that question, so I'll take them in turn. If I look at what suppliers should do now, first of all, there will be a range of options which will depend upon the contract and the arrangements in place. As a start, I'd recommend that they proactively consider any relevant contracts and relationships. They need to look at the areas of exposure, either to working capital or to any particular credit risks. They should start to tighten up on credit and any grace periods that have been offered. then check when the right to terminate arises. Are the terms broad enough? Is there sufficient scope? As I've said, the new law doesn't prevent reliance on post-insolvency termination events. Have a look whether the right to terminate has arisen. If it has, consider if you need to or if you want to use that as a tool to renegotiate the current contract. And the above all message, which we've all lived in with the last 3 months, is be vigilant, just be aware.
Mm-hmm.
And then if I take your second question, Chris, what if the supplier can't afford to supply? The starting point is that suppliers are not obliged to supply if they can prove they will suffer hardship. Hardship isn't defined though, so this will become the subject of some debate. What the government guidance says is that the threshold is going to be particularly high, and it's going to be something closer to the supplier's own insolvency or risk thereof. If hardship is of concern, then practically I'd advise speaking to the customer, the insolvency practitioner, as a start to explain the difficulty and ask whether they can agree terms or vary the terms of supply in a way that works for both of them, or if they can actually cease to supply. If they simply stop supplying, then the customer will face a risk of, the supplier will face the risk of the customer taking them to court in order to force supply, and potentially the cost consequences of that. Whether the customer does that will very much depend on how important the supplier is to that customer's recovery. I should add, there is a small exemption that applies at the moment to small businesses, small entities. So until the 30th of September, a business that is classed as a small entity can't be forced to supply. They're exempt from this. They are caught by it post 30th of September unless the government takes further action. Broadly, a small business is a business that has a turnover of 10.2 million or less, a balance sheet of 5.1 million or less, or 50 employees or less. You've got to fit 2 of those criteria.
It seems to me that you know, this could be taking it to the wire for a lot of suppliers, couldn't it? Really, you know, if it's got a border on your own insolvency before you can claim some support for hardship. So I don't know. When should suppliers act? The earlier the better. It seems to me. No.
Yes, exactly that, Chris. Even if you are one of the exempt small entities, this is going to hit you at some point. This, quite frankly, is simply about suppliers having some control over their own destiny by retaining a level of control over the risk they're prepared to accept. We're in a climate where more businesses than ever are facing their own mortality, and in my view, this is not a time to be complacent. Once your customer is in that process, it's too late. You're at their mercy, applying to court, pleading hardship, or looking at another termination provision you may trigger.
What about on the flip side of the coin? And then what does it mean for customers as opposed to the supplier? Then the other end of the contract.
The law is intended to benefit customers. It's intended to help the customer that's facing financial distress, to help them to recover. The unintended consequence may be, however, that as suppliers look at their own risks and their own options, that the customers face tighter credit control. They may face early termination of a contract, which could frustrate their own recovery, and they're going to face renegotiation of terms. The reality, though, is we're living in a world where the government is saying try to look after each other. That's not going to be possible in every case, but the measures are aimed at saving businesses. And if a customer is approached by a supplier, as the supply chain is so carefully balanced and we've got further risks of Brexit looming, I recommend just engaging with the critical suppliers and looking to see if we can agree terms that work for both parties.
I think perhaps what Kate said earlier on, pragmatism and common sense will hopefully come to the fore in solving a lot of these a lot of these issues if they do materialise. So yeah, I said very thought-provoking, Mel. Very thought-provoking. I think something for all businesses to consider there. So I think we're going to now try and launch our third poll, and hopefully I'll get the right one this time. So let's have a go. Poll 3. There we go. There we are. And whilst that is hitting everybody, in terms of an insolvency side of things, Mel, any live examples you want to share with us that you think would be pertinent?
Yes, so it's more on the restructuring side, because a huge part of what I'm about is trying to ensure the survival of the business and avoid the process. We've helped a number of clients. One particular instance, we assisted a supplier. It was a supplier of goods, and they were looking to renegotiate the terms of a rolling contract following a 3-month pause on their orders. We helped the supplier to manage its own exposure by securing an immediate payment of a significant sum in arrear, albeit at a discounted level. A commercial decision was taken to get the cash in, even if not all of it. But alongside that, we managed to negotiate variations to their trading contract, their relationship. So we reduced the payment period for future invoices. We inserted clearer rights to suspend their obligations, and we imposed critically credit limits to both age, debt and order volumes, which gave them the control over their working capital. Honestly, had they not come to us and had their customer entered into an insolvency process, given the working capital requirements, their future might have been quite different.
Yeah, indeed. Thank you very much for that, Mel. Again, insightful as ever. Our poll is still running. The responses are coming in, and I'll give that a few more minutes to finalise, and then perhaps we can move on to some Q&As that we have coming in. I think that's probably the end of our poll now for you, Mel. So we'll just finish that. Great. So that's quite an interesting one there, Mel. If you want to just pick, can you see those results which are coming in?
Yes, so it's interesting that there's enough people on here that are aware that if one or more customers go bust, that will have a significant impact on them.
I think that is, that says an awful lot, doesn't it? Really, in terms of the concern people have if this really does come through and an insolvency occurs. So
in terms of timings, I think we need to look at the accrual of debt and particularly, I've noticed comments on here around landlords, the accrual of rent. We've gone through 2 quarter days, and we've got a 3rd quarter day coming in September for many businesses. And I can see a lot of decisions, they're being taken now, but will be taken as we go through the summer and into the autumn period as that rent day hits us.
Mm-hmm. It's interesting as well that 63% of those voting think that the changes aren't for the better. So there's obviously concern out there.
Yeah,
I don't know whether
most are suppliers.
Well, exactly. Yes.
So yes, I can understand that.
It's going to be interesting, actually. Perhaps this is a related topic that we might be able to pick up in our next webinar. If we're looking at cash flow issues, it might be something that we can relate back there. So that'll be a very interesting one. Right, let's go to that. Should we just have a look now if we've had any? We didn't have the chance to have a look at your poll results, Caroline, did we? So when we moved on. So there we are. That's sharing your poll results. So
yeah, it's interesting. Out of everyone who has submitted, no one has been successful, which mirrors the kind of anecdotally what we're hearing out of the industry.
Yes, exactly. Yeah, 23% have tried to claim, but as I say, no success with a couple of decisions awaiting by the looks of it. So yeah, that tells a story, doesn't it? Yeah, indeed. Okay. Thank you, folks. Right then, shall we just have a look what questions that we've got coming in?
Will I take the one that relates to commercial property leases and force majeure? We've got a question from Mike asking, is there anything in the typical commercial property lease contract that a tenant might claim offers a force majeure defence to excuse non-payment of rent? Really good question. I think it's very unlikely that any force majeure clause in a lease, and they aren't always included in leases, I'm not a property lawyer, but some leases will have them, some won't. If there is a force majeure clause in a lease, I think it's very unlikely that inability to pay would be deemed to be a force majeure event. Highly unlikely.
Okay.
Hope that answers your question, Mike.
Good. And there's another one there from Mike Satcher, Kate, but did you say that's that one that you'll probably take offline?
I'm not a property lawyer, but with a caveat, I can give some initial thoughts on that. Mm-hmm. The government, as I've said, wants people to work together. Their landlords are currently precluded from taking any enforcement action against commercial tenants until the 23rd of August. So they cannot take steps to remove you. They may be able to exercise CRA, so I would need to check that. Landlords are also prevented from presenting statutory demands in the period up to any time before the 30th of September and relying on those as evidence of insolvency. And they will not be able to get a petition to wind up before the court unless they are able to demonstrate that your inability to pay is not as a result of COVID. So if it's a pre-COVID debt and it's quite old, they may be able to get a petition into court. But if this is all post-COVID rent, then you are in a stronger position. We've also got government guidance that says that in the commercial property space that's urging landlords and tenants to work together. So right now there's very little I think they can do. So it is worth staying strong and trying to maintain that dialogue. But I will go back to the property litigators and check that point and come back to you.
Okay. There's another question which has come through. Could you where's it gone? Could you please discuss the interaction between section 233A and section 233B of the Insolvency Act when it comes to the providers of essential supplies? So I guess that's you again, Mal.
Yes. 233A still applies. That came into force on the 1st of October 2015. So where you are a supplier of a 233A essential supply that entered into a contract with your customer before the 1st of October 2015, section 233B applies, and you are bound to continue supplies and services without the provision of a guarantee by the insolvency practitioner. If you're an essential supplier that entered into a contract with the customer post 1st October 2015, 233A applies, and you can only be bound to supply if the insolvency practitioner provides you with a guarantee within 28 days of asking you to supply. I would need to check the interaction and what that means for the new moratorium. But in terms of administrations, liquidations, 233A remains the same.
Okay, that's great. Thanks very much, Mel. I think probably one for you, Caroline. What's the current state of play on test cases for insurance complaint claims as a result of COVID?
So this is the Financial Conduct Authority's case. It is due to, the trial of it is due to happen in the last week of July. I anticipate that the judgment on that will be rushed through and is likely to come in the first couple of weeks of August, but we haven't got a precise date for the judgment as yet. And as I say, I expect that there'll be an appeal, so getting to a final court decision on that is likely to be towards the back end of the year.
Okay.
And
Thanks,
I think there was one more for me,
that's
which
right, yeah.
from Lisa. Lisa said that they've encountered a tricky circumstance where on the renewal of their policy, they asked if the current policy covered COVID, and were told it did. When they renewed and they then made a claim on the policy, their claim was denied. She's asked whether we've come across that circumstance and whether she should pursue it any further. We haven't had a direct situation along those lines. It sounds very odd. What we are hearing from the industry is obviously because COVID didn't exist before December 2019. Most policies that specified the notifiable diseases that they covered won't kick in and cover COVID losses. Where a policy was more general and covered certain types of pandemic diseases, they were more likely to cover. But since then, the insurers have tightened up their policies and expressly excluded COVID losses. If you weren't covered, if COVID was covered and then and you are being told you are now not covered, I think that your insurers have probably changed their policy. But if at the time you took that policy out, you were told you would be covered, you certainly need to be pursuing it further. And I'd suggest an initial complaint to the insurer, followed up by pursuing the issue through Financial Ombudsman Service or through a court claim.
Okay, that's lovely. Thanks, Caroline. I think there was one question, Chris Lennon. Chris, I can't see all the question, but so perhaps that's something that we could follow up on afterwards. So, and
I think Peter Thompson also has a query. Hi, Peter.
Oh yes, sorry, Peter. Yeah.
Is the law of frustration a get out of jail card? How widespread is it being used? It is and it isn't. Yes, it is, because if you have a genuinely frustrated contract because it simply cannot be performed at that present time, yeah, I guess it does feel a bit like a get out of jail free card, except it's not free because under statute and common law, actually, that there is the ability for a party who's already paid to get some money back. That might not be ideal depending on what the contract actually is. So I'd always much rather usually rely on force majeure rather than frustration. There's also probably less uncertainty with force majeure. Something is genuinely frustrated can be the subject of disputes, and obviously a dispute is not where you want to end up. In terms of how widespread is it being used, I've not seen it come into play in any of the contracts I've been looking at. I don't know about Caroline and Mel. There is quite a lot of case law around frustration, but quite a lot of it harks back to many years ago. And I think what I read from that is that parties tend to try and settle a frustration claim rather than it ending up in the courts, which indicates common sense, pragmatism, and you don't really want to get lawyers involved in a dispute about frustration if you can possibly help it.
Cool. Okay. Well, folks, I think that is the end of the questions now, and I think my notice that time is marching on. If there are any other issues that any of the participants would like to raise offline, please do so. We've got a team of experts here who'll be more than willing to help you. So finally, on behalf of myself, I'd just like to thank all the participants for joining. I hope you've really found it thought-provoking and enlightening in terms of what we've tried to do here. I'd like to thank all the panelists as well, really, who thought long and hard about the presentations and the information that they're sharing with you. So again, hope that's been extremely useful for you. As I mentioned, the webinar has been recorded and it will be launched via social media feeds, etc. So there will be a point of reference for everybody to pick up on them. And if you feel it's worth, you can share it with others, please do so. Hope you've enjoyed it. And hopefully we will see you on the 28th of July for the second of our webinars in this series. So have a good evening. What's the time? It's just gone 10 to 5. You should be able to get a little bit of antiques restoration in, I think, before pointless. So have a good evening, everybody.